Good afternoon, everybody. Thank you for coming here into the classroom. Thank you for being online as well. My name is Ondřej. I've got like 20 years of experience in M&A, going through 2 law firms, international law firms, in various positions before we set up a local boutique law firm 7 years ago, I guess. 7 years ago. Now we got like 10 partners specializing in M&A. We're internationally recognized, but that's not the important part. All you need to know about me is up there, and I may use the opportunity to get to know you. Who's in the laws? Who's got some experience with law? Who is studying law? If you want, put your hands up. Law. And who's into business more? Okay. Is there someone who's from a technical background, like IT, architecture? No? No, except for our IT guys up there. Good, good. The reason why I'm asking is that actually the M&A, mergers and acquisition, luckily it's not about law that much as other areas of law. It's not about the statutes. It's not about going through precedents. It's more about knowing. Legally, it's more about knowing the principles, knowing the standards, and beside the legal part, a very important part of that, I would say, 70% is the finance, the most important part, 20% is the law, and 10% is the common sense. That's why I was asking for the IT guys here, because the common sense, they do understand it. They do understand transactions. Also, they don't have any formal education in M&A because of the way they think about the transactions. The IT guys, I find, to have them on board when you are negotiating a transaction. As a lawyer, you must fully rely on the people who understands the economic of the target firm, who understands the economic of the transaction. Because as a lawyer, you somehow get to know to the economic of the transactions, but you'll never have time in the transaction to do your calculations. Even if you know how to do the calculations, you have to rely on your finance or economic team. And the other way around is the easier part. Be sure that when you are in a transaction, the economic people fully rely on you in any legal matters. They do have a legal education from their schools, but they don't want to apply. It's not their job. They fully rely on you. So when we're talking about M&A, it's actually 3 parts. The finance, which is the most important because you want to get the money out of it. So is the finance. I said 70%, but let's say 60%. 25% is the laws. And as I mentioned, it's not the act. It's not going through precedent. It's not about reading books. It's about knowing the principles, applying the principles, and knowing the standards of M&A. And the remaining 15 or 10% is the common sense, which makes the difference between a good transaction and a bad transaction. You can have 10 transactions a year, but when the teams are able or are using the common sense, the transaction, that transaction will be much better than those transactions which are legally and economically perfect. You'll never get the good result without having someone who's using the common people sense. Before we start with the topic, let's agree on what M&A means, mergers and acquisitions. When we get, because everybody says, I'm M&A lawyer, I work for M&A. You can read about the M&A market going up in your country or critically decreasing the number of transactions in the M&A market. So that M&A means, many various types of transactions. So first, let's devote some time and And let's define, for the purposes of this presentation and our discussions, what M&A means. Then we will look at a typical M&A structure. Then we'll be going from theory, we'll be going to practice. I got some samples here from our engagements with the client. I can't tell you the names of the client, but you will get the precise material which we get and the instructions which we get from the client. And I will show you the solution and just describe the way how we got there. And it might be up to you then when looking back to the presentation to repeat the way we achieved the result. So we'll go pretty much into practice. And I mentioned in the beginning, I don't want to stick to the laws. I don't want to be boring for the financial guys. So I always will try to get some finance into our legal discussions as well. And this will be pretty much in the M&A process, which will be the third part, because as I'm trying to explain to the client, you can be the best lawyer in the world, you can be the best economic advisor in the world, you can own Google, but if you don't manage the process of M&A, it's only administration, but if you don't manage it, you will never get a good result out of the process, out of the sale of the company, or out of the purchase of the company. Even if you are the best, but you spoil the process, and you can spoil it actually right in the beginning, and you'll never get it into into a good end. So when this happens, the transaction will be a disaster. And I'm telling to all junior people, first concentrate on the process, M&A, and then go into M&A documents, into the details. The third part of this presentation will be a due diligence. I guess you've heard the term due diligence before. It's actually, if I would like to buy a company, as a business owner, I would like to buy another business. I get some basic information in the beginning. I go to the business and tell them, I would like to buy you for $1,000 because I assume the information you gave me are correct. They say, okay, we're fine with $1,000. We will sell you the company for $1,000. And I say to them, wait, first I go my due diligence because I need to check that the information which you gave me and on the basis on which I calculated the purchase price are correct. I will come back to you in 1 week, and if the information are correct, I pay you $1,000, as we just agreed. If the information is not correct, I will pay you less, because the information you gave me on the basis of which I calculated the purchase price were not correct. So I need to renegotiate the purchase price. So the due diligence process is a process when I look into the company and I'm trying to get as much information from the company as possible. And I will tell you stories about how the sellers of the companies do not want to give you the information. I will tell you stories about torturing the opposite side lawyers, keeping them in hot, small rooms without windows, not giving them information online, just handing over papers, not letting them having their phones online with them so that they can copy. I will come up with some war stories as well. And at the end, that's quite a difficult part. We look into the main transaction documents. The most important transaction document is always the purchase agreement. It's of course the sale or the purchase agreement. The good thing is, if you once get to know with the structure of this SPA, sale share purchase agreement, you'll know all the share purchase agreement in the world. You will be able to read that through once you get to know the structure. So I know it's in the beginning. I know it will be quite difficult unless you have studied this topic before. But once you get to know with a template template share purchase agreement, which I will describe to you here, then you'll have the opportunity then for the next 10 years until the template, or for the next 20 years, 30 years, until the templates change, you'll be able, whenever you get a share purchase agreement in any country, you'll be able to get yourself oriented and to read it through very easily. So that would be the focus of the last part. So let's start. What is mergers and acquisition? What is M&A? M&A stands for mergers and acquisitions. Mergers legally means combining two companies together. It has nothing to do with acquisitions. It's something else. Merger, you are the business, I am the business owner, I have two companies. I don't want, this one is dormant, doesn't have any business, I interrupted the business, I don't want it anymore. This one is a super company which earns me money. So why should I keep this company alive? I simply put them together. There is no acquisition. I was the owner of both the companies, and I put them together. So that's legally a merger. So combining companies together. When I do a merger, I don't need to do the acquisition. It's just a mergers and acquisition, but it's an absolutely different type of work, and I will show it to you later. When I do an acquisition, it means that I, as a buyer, buy a company, buy a business from someone else. I don't do any mergers. I don't take his company and put it together with my company. No, I'm the buyer, I buy his company. So that's the difference. So if you are saying, I am M&A lawyer, you should know both the mergers and the acquisitions, but frankly speaking, mergers are not, it's not that topic as the acquisitions. Mergers typically are done in practice. The mergers are done typically intra-group. It means two companies having the same owner are for various reasons combined together. It's more, I would say, more an administration process than a legal problematic process or legally difficult process. It's more about administration.
Well, as you just mentioned that acquiring company, I mean, in the form of acquisition, what should be the percentage of ownership that you have to acquire, or what should be the minimum threshold of the percentage that you have to acquire?
Good question, and we will get to them. Get to that. So the question is, if we are not in the mergers, we're in the acquisition. So I am considering buying a company of my friend because my friend has started another business and he doesn't care for this company, but I'm interested. I think his old business is good for me, so I want to buy it from him. So what's the rule? What's the best result? There is a saying that two for, how to translate that exactly? 2 for business are too much. So ideally, you can be the sole shareholder, the sole owner of the company. In practice, it doesn't work. You need your partners. You need your old friend to stay there for some time to hand over the business to you in the company. You may not have enough cash in the beginning to pay your employees, so maybe you give them a share in the company. Maybe you're good in law, but you're not that strong in finance. So you take a finance guy on board. The finance guys now typically ask you for a share or at least a share in a profit. But if you are a starting company, the finance guy may ask for a share as well. So to answer your questions, what percentage of a company you should buy to be sure that everything goes as you planned? So ideally 100%, but in practice you will not make it because you cannot make it alone. You need people around you. So even if you give 1% to another person, the 1% shareholder will require, let's say, a blocking minority for some decisions, such as if you want to invest more money into the company from your pocket, you give the money to your company. So the small shareholder will ask you, I want to have in my agreement, then I will not be required to pay the money as well. Because it's your company, I have 1% only. I don't want to pay, I don't want to get money in this. I put my brain on it, I work for you, but I will not invest money on that. So he will have, even if you own 99% of the voting rights, you will never be able to vote through a decision on putting money into the company from your pockets because he can block you contractually. So I would say, generally speaking, more than 60% is a full control of the company. It's okay, you can vote through everything, but on the other hand, even if you have 1% shareholder or 0.1 shareholder, 0.1% shareholder, he will definitely have some blocking minority, some blocking rights on some of the decisions, and we can get to that later. So we discussed now the acquisitions before we discuss the mergers, and for the purposes of this presentation, let's say we'll be talking about acquisitions. Whenever I say mergers, acquisition, it means buying, selling companies. This should be the topic, actually. However, in the beginning, we'll go to the mergers, and I just explain what is the merger, how a merger can be done in 2 slides, very easy. And then I will show you what typically the internal lawyers, in-house lawyers, are asked to structure, are asked to do when they are asked to do mergers. So please don't get me wrong. Mergers as such, joining companies, can be fun as well. But in my experience, buying and selling companies, it's more fun because you have always people there, and you have the story behind the company which is being sold. Imagine your fathers who established their companies before you were born. As you grown up, his company has grown up, or your parents' company has grown up, and now there is a time when they decided to sell the company. So it's like selling a company for someone is like saying goodbye to your baby. So there is always a very intense story if you are the seller of the company. So we'll get to that. So that's why I think buying and selling companies is more fun than doing mergers only.
Mergers cannot be, done with different companies. You have to be same owner. This is a condition that yes, he has to be same owner in the form of a merger of companies, right? Or 2 different companies, they can bring 50% ownership, and then they can merge together and to have another organization.
Absolutely correct, because typically 99% of mergers, I don't have the statistic, but I would guess 95% of the mergers would be intragroup. The same owner merges 2, 3, 4, 5 of his companies together. But in larger deals, there might be a merger where one company is owned by other owners than the second company. It might be the case, and it means that the owners, the owners 1 and owners 2, will merge their companies and create one big company with various percentage on their side. So to answer your question, yes, a merger can be done between unrelated persons, and it would, in some way, it would substitute the acquisition. Typically, if you don't have enough money to buy a very large global company, and you are the second largest global company in in this area, you offer a merger because nobody would borrow you the cash so that you buy a big competitor. But you can make a combination. You can make a combined company and remain the shareholder as well of both companies. Finally, so to answer your question, yes, it's possible to merge two unrelated companies. But I would say in practice, it's a minority of transactions. So let's first start with the mergers, not acquisition. So the less fun in the beginning. I already explained that a merger means combining 1, 2, 3, 4, 50 companies together. The way you can combine the companies together is that you have one company which will be the surviving one, and you have a company which will be the merged one, the one which ceased to exist. And you put the small companies which should cease to exist into the big one, so that you get one company and one surviving company. Or I can show you here. I can show you here. It would be better if I show you this. Okay, so here you are the owner, and you decided to keep this company alive, the surviving company. So you simply merge this disappearing company into this surviving company. What happened? One company is not existing, and the surviving company continues to exist. However, the assets of the disappearing company are here in the surviving entity, in the surviving company. No new companies involved, no new companies originated. You just combined your old companies into, or you just combined your one old disappearing company into your old surviving company. It can be also the other way around. And I will then tell you why, and we will then discuss what is legal and what is illegal in mergers. And I must tell you then that during the past years, we have seen, like, in due diligence, we came across mergers which were apparently illegal, which means they should have no effect. And I would say it's 10% of the mergers which we reviewed. But I'll get to that. So the other way around, if you as an owner want to discontinue your company one, disappearing company one, and discontinue also your disappearing company two. So you can do it. You will, in the merger, within the merger process, you will simply, as a result of the merger, create a new company which will own the assets and have the liabilities of both of your disappearing companies. The result is that there is a brand new company which can be like 14 days old, 3 days old, and it will have assets and liabilities, but assets and liabilities only, not the corporate structure of the disappearing companies. Can you guess why would some owners like to do it? What would be the reason for keeping the assets, keeping the liabilities, keeping the debts, keeping the debtors, but creating a new company, a new corporate structure?
Because it has a bad name on the market.
Bad name on the market, exactly.
I guess, like, especially here in Czech Republic, what's happening on the Bankrat, like this investing company.
It can be you can't simply, if you are disappearing a company, you can't, if you're doing illegal things, you can't get off debt which you own to a bank from a disappearing company. the new company will have the debt as well. It's not that you play tricks on the bank. No, the new company will have the debt as well. But the new company will have another company number, another seat, another name, and at the first sight, no relation to the original company. Another reason is a legal reason. It may happen that especially the very old companies, they might have legal problems in the history, such as an example, I am the 100% owner now, but in the beginning, I had a colleague who owned 2%. We disagreed, he left the company, and we somehow did the transfer of his shares to me over the weekend. Lawyers didn't see it, economic advisors didn't see it, so we somehow did it using the templates from internet, and then the next 30 years I was the owner of his share and my share, disappearing company. But then I decided to sell this company to someone. He sent his lawyers there, and the lawyers say, hey, we saw the documents from the past, and when you were buying the 2% from your colleague, you made a mistake. There is a risk that when your former colleague gets to know that we are the new owner of the company, of the disappearing company, he will come to us and he will say, hey, you're not the 100% owner, I am the 2% owner. Because some clever lawyer will advise him that he can get money from you for bringing the claim. In practice, what would happen? In practice, the new owner will rather pay to the former colleague a settlement than to go to the court and to be sued by a former shareholder of the disappearing company. This would mean, for his investment, it would mean a huge problem, which can affect not only the 2%, but the entire company. So, if I'm an owner who knows or got to know that there was a corporate problem in buying the shares in this company, what I do the merger, I cancel this disappearing company, I cancel also the other company and create a new company which has no legal history, except for the last 3 days when I founded that. Once the merger is completed, nobody for the new company, which has nothing to do with the disappearing company, nobody can make any claims for the shares of this company. So you may actually, by the merger, you can heal not only the problems with reputation, with a good business name, but also you may use it to repair illegal defects from the very, very past. But
What could be the legal defect? Like, I mean, like from what you have been describing, I see like the process when like you guys like just like set some document and send it to the registry itself, like the court, and then the court like signed the 100% shareholder, the one who acquires 2%. So what could be this legal defect?
okay, the question now is, what could be the historical legal problem which I would like to solve within the merger, or with the help of the merger of the companies and creating new company as a result of the merger. One was, as I mentioned, a problem with the share transfer, because in many jurisdictions, especially here in Central Europe, the fact that you are registered as the company owner in the register doesn't mean that you are actually the owner. There might be someone who can challenge this. So the registration doesn't mean you have healed the problem. You can persuade the court the registration court to register something which is incorrect, because simply you make the application and you don't file all the documents, so the judge can't really see what the problem was. So it can be the problem. Another problem, what we saw in the past was, well, it's a problem which we saw really in the past. It's now we don't see these problems anymore. But when the lawyers look at this disappearing company, they actually find out that the company is non-existing. And imagine you are a business owner, you run the company for 30 years, and then a 25-year-old lawyer come to you and say, look, your company never existed legally. They say, well, I got employees, I got buildings, I got cars, I got the production line, we're selling abroad. They said, no, legally you're not existing. There might be a problem in the foundation documents. So this can be a problem. And I would say, then let me think about typically it was the share transfers and the foundations of the and the creation of the company problems.
So what would be about the liabilities? I mean, if disappearing company is hiding the liabilities to the new mergers, I mean, so how you will deal or what will be happen to liability? Because once he will disappear the company, it means he is not owner of that company.
Right.
So
right.
and company doesn't exist, and natural person cannot be liable for any liability on behalf of the company he used to own in the past.
We will get to the liability of the sellers in the acquisitions, and I'll combine it with your response to the merger here. Because as a rule, everything, the debts, the cash, the good and the bad in this disappearing company automatically goes into the new company. This is the rule for mergers. Even if the new company doesn't know there is a liability or there is a cash or there is an asset like a villa in Bahamas owned by this company, it automatically goes into the new company, even if the new company doesn't know. But I'll get to the liability of the one who actually made a mistake here by not stating all the liabilities and all the assets of the disappearing company. I'll get to that. It's the topic, very important topic as well. So I promise to you that well, you see, these types of mergers, it was very simple. It was the theory. You have two companies, one survives, the other is cancelled. You have two companies are cancelled, and a new company is created. This is practice. Let's go. This was the theory. Let's go to the practice now. I mentioned that I will show you an engagement which we actually got from a client. I can't really tell you the name, but it's one of the largest food production companies in Europe. So I'll give you some time to look at the company chart, to look at the company structure. As you can see, up there is a holding company. Let's say it's the owners. Then companies which are marked blue are in one state, European state. The red companies are in one European state. The yellow companies are in one European state. And we have two types of companies. One is the production company only. It means a company which owns a production factory. So real estate, employees, a production line. There are also companies which are production, meaning they have the production plant, and they also have their own sales forces. I mean, sales department, their own marketing, their own contracts with the customers. And I think there was one company which was only sales company. It didn't have any production. But for some historical reason, it was under one of the local companies. It provided services to the mother company, to the other company in the other state, and as far as I recall, to one of the companies. So a mess, you know. And the instruction for us was, just a second. The instruction for us as the lawyers was do the mergers so that we have all the sales for the entire group in the new sales company. So this was the first instruction from the owner. The second instruction from the owner was, well, I produce food. I have 4 factories in this country. Why should I have 4 companies? One company can own all the 4 production plants. It's not a problem. I will reduce costs. I will reduce the number of the advisors, the lawyers on each of the company, and I will have a unique management for all the companies, for all the production plants, which is good because one production plant is missing something. So under a unique management, unified management, the other production company can make the production because all the production plants would be under one company. So first, what we did is, just to make it more difficult, we procured a demerger, which means a spin-off of sales activities into the new company. So we got to these guys down there and told them, hey, your sales department will be legally separated from your company and will be put into the new sales company. The same applies for these guys. The same applies for this guy. And we said, well, the old sales company doesn't make sense to have new sales company and the old sales company. So the yellow sales companies merged together, and we had like one sales department located in one of the countries, responsible for all the countries and responsible for all the production plants. What's also important, reporting directly to the owners, because the sales became more important at that times. If you leave the sales here, they will report to the local management. The local management will report to semi-holding company. The semi-holding company will report together with all the other reports to the owners. So the owners will get limited information on the sale process. And they said improving the sales is the future of our group. So we need to have direct control here. So that's why all the sales merging into the new sales company or demerging, being spin-off to the company. And as you can guess, probably for each of the country, we merged 3 companies in this country, 4 companies in this country, and we made a mistake. We merged these 2 companies together as well. So the result, well, we merged them because they are blue. They are in one country. And let me show you the result. This is the final structure. Very simple. Owners still at the top. Direct control over the sales. The sales responsible for the entire group. Directly responsible to the owners. Then there was a company in one of the European countries. It was a production company, and there was one production company in the other European country which had like 4 production plants, production factories, and then the yellow, a production company in the 3rd European country which owned 4 production plants, 4 production factories. So we made it simple. Well, the first thing was, the instruction was, we want to have the sales there. So it was important. Who else would appreciate it? If you think, well, it's a big group, it has own financing, it has dividends, but there is always a bank or someone who provides the financing into the group. And be sure that when you are a bank, being a local bank, for example, and you let the money flow somewhere, let's say here, to that company, because you are a bank here in the red country, you you give a loan to this production company. Be sure that the monies will go here around. It is legal, but the problem is you as a small local bank here, you have no control over it. You don't have any information where the money flows actually. Because, you know, this company can sell services to this company, and this company will pay with the bank money to this company. So the bank money will be here. You know, as a bank, you don't want it. As a bank, you want this structure. You want to make sure that when you put money here, that there are 4 companies, that there are 4 factories, production factories, production plants under this company, and probably the money will flow into the production here rather than into another production company, because it's a production company, doesn't sell services. You know, so it's good for the banks. The banks sometimes require this. And finally, it was good for an investor, for a US investment fund, which acquired 3 or 4 years ago. They acquired the entire group, which is still existing in this structure. Because imagine that you are a manager, and we'll get to that as well. You are a manager. You get your reports from your advisors saying, well, there is no problem, no obvious problems in the company. The finance are fine. Legal, well, there are some issues, but not that important. So, you know, that's it. And decide if you are able, you know, once you can be in a position when you get these 2 reports, the legal report and the financial report, and on the basis of that, you should decide, or you should tell to your owner whether to purchase such a complex group. Well, what would you think? Have the lawyers done their work good? Isn't that too complicated, so that once I buy it, I will not see where the money flows? It can be, you know, you can have questions if you invest in specific jurisdictions. You can say, will there be corruption among the companies? Will I be able to control corruption if I have 3 board members in each of the companies? So that's why the mergers. That's why this was the structure which was finally fine for the investor, for the bank, and for the owners as well. I mentioned that we in the past we came across, when doing due diligence, when looking into the history of the mergers, we came across, like I would say, fatal mistakes, mistakes which can't be repeated, steps because the steps which has been done in the merger process are illegal. Not illegal because someone wanted to do a crime, not at all. Illegal because of one thing. You can't do a merger because you like this less than this. This is nice picture, this is awful picture. You know, as an owner, and you know, I can go much further. Here, if I decide for the merger in any European legal system, in any European country, and I guess in other countries as well, you have the basic principle. The merger must have economic reasoning. So if you can do a super merger, legally absolutely perfect, nothing missing. Everybody knows what are the assets in the disappearing company. Everybody knows what are the liabilities and debts of the disappearing company. The surviving company is happy to take over these assets and liabilities of the disappearing company. The owner is happy to have one company at the final stage, and you know the registration court will probably confirm the merger, delete the disappearing company from the public registers, and register the owner as the only owner of the surviving company. This is fine. I bet you would be able to push that through in 95% of 99% of cases. You'll be able to push the registration of the merger in the public register. But what is illegal and what makes the merger invalid, and anyone can challenge the merger, the merger even many years after the merger has been completed and the disappearing company deleted from all public registers. So the reason is that there was no economic reason for doing the merger. And I tell you what, I bet you have this principle in your legal system, and just to understand these principles, I believe that none of the legal system will say economically justifiable merger is that you save costs, the picture is nicer, you can see to the bottom of your group of companies, you reduce the number of management staff because you have less companies. No legal system will state that. It's up to you. It's up to you to find out and to put the reasoning, the economic reasoning of the merger into the documents. If you don't do it, or if you are unable to defend someone's claim that the merger doesn't make economic sense, the merger will be invalid, non-existing. It will, in certain jurisdictions, it will have to go reverse somehow into the original two companies. Very difficult, legally, from the tax perspective, accounting perspective, I would say impossible almost. Why is the reason for that? If you don't have the rule that the merger must have some economic reasons, what would you do? You as an owner or a businessman, you create two companies. This company will be the super cash cow. You'll get all the business here. It will have super profit, ready to pay dividends up there to me. This company is mine as well, but you know, it isn't a problem. It is in problems, it has loss, it has tax losses. So what I would do, I would simply merge this company into the surviving company and say, well, there was a tax loss, so let's get a tax loss here, and I will await the high taxes, which I would otherwise need to pay here, because this company is a super earning company. So if I don't have the rule, and try to find out with a better rule which would prevent these tax evasions, I don't see anyone saying it doesn't make economic sense. If you are an owner, you have one company which is super, one company which is almost bankrupt. It was up to you, it was your decision. What is the reason for putting them together economically, practically? No.
Excuse me, so who will decide that what is the intention behind? Is it an economic, or he's avoiding taxes, or he's avoiding the liabilities? So who will decide? I mean, the court will decide, or while he passing through the merger process. So which authority will decide? Or if they have done this merger successfully, and later it is revealed that there was like bad intention behind, not economic, the reason to merge them. So what will be the remedies available?
Okay, so the question is, who will decide whether the economic reasons of the mergers are sufficient or insufficient? And what is the authority here? In practice, it would be the financial authority. When they find out there was a merger, they will look into that, whether this principle was applied. The registration court typically will not do it, because the registration courts typically don't have enough economic information on the merger. They do have the legal information, and legally the merger can be fine. So it's going to be the financial authority. It can happen then if you are, after many years, selling the company to someone, the buyer will come and say, well, we see the problem here in the past. It was not economically justifiable, your merger. We see a risk, so we will not pay you the money you want. We'll pay you less. So it can be someone private. But I would say the risk, or the authority responsible, is the financial authority.
But what will be the remedy? I mean, the other people who might be owing, some rights and liabilities toward that company.
I never came across a case where someone said, we're going to split the company and give it back to this stage before the merger. But Czech laws say this should be done. This should be done. But I can't imagine how we can do it from tax perspective, accounting perspective. We don't have any experience with that in the Czech Republic. But the law said it should be separated. And imagine you are asked to do it 3 years after the merger has been completed. So I hope I will never come across a case like this, but it can happen. So let's go to the next part, which is selling and buying companies. I would say when someone's talking about M&A, he's talking mergers and acquisitions, he's talking about buying and selling companies. Very easily, what a sale of a company means, I am the seller, I am the business owner, I have my beautiful company here which produces clothes, for example, jeans. There is a buyer which has cash, and the buyer wants to place the cash somewhere to make it work, to get profit out of his cash. So he establishes his acquisition company and buys my share in the target, so that I'm out with my purchase price with me on my bank account. The buyer doesn't have the cash, which he had in the beginning, but instead of the cash, he has his acquisition vehicle here, the company which is the buyer, and my former production company here. So this is the simplest sale of the company. You just tell me now. Don't think about law. Don't think about economics. Just tell me from, if you were a business owner, what would be the most obvious reasons for selling your company or buying another company? Let's start with selling a company. Why would I sell my? Or no, let's start with buying a company. Why would I buy a company of someone else?
For new frontiers, enter the markets.
Exactly.
For financial reasons.
Exactly. I heard access to new markets, access to something. New markets are the perfect fit.
For example, I don't have a pattern for something, but the company I wish to buy has this pattern and their profits. Also, I can buy the company to get that pattern. Actually.
Exactly.
If I cannot develop something by my own, I can buy a company which has that technology and pattern.
If I have access to the cash, it makes more sense than to develop it, because it will be expensive to buy it, as you're saying.
For example, I want to develop a new line of products, like completely new things, like so I can buy a company which can do it.
Right. And it's, as you mentioned, it's the access to the market, and you mentioned access to technology, access to know-how. That's exactly, and your thinking would be, if you are the one who's got the money and ready to invest, so you will not think about legal stuff, but what you will consider. If I put the cash into development of the know-how, will I need to put more than if I look on the market and I find the company, a small company which has the know-how, and I pay for the company less?
It can be cheaper than
Exactly.
wasting money developing.
And there is much less risk in buying a functioning company than to trying to develop something, because you can lose people, you may not find new people, the development may be difficult,
Or it's sometimes easier to buy a company than set up your own.
Right.
Because they have the working by business process, which is very good, so you can just buy a previously made company, all these checks, and be an owner of an already succeeded business.
Super.
Better than risking.
Right.
But I think so in this case.
Sorry, you corrected me, right? Because I said it's all about money. It's not, but it's not true. It's about the risks, as you mentioned as well. It's both. Sorry.
Yeah. I mean, might be it will get closer to franchise business, because if they have, already established brand and the product line, of course they will not going to sell now. They will going to be franchise now. I mean, so in such scenario, if you have, well brand, good product line, so they will not sell the business. Might be if they can sell if they have a good value they're receiving, but most of the time they would go for a franchise business, I believe.
Exactly, because if there is someone specific you love, they will not let you into their business, because what they would be scared is, you go there, you send your lawyers, you send your advisors, they will get the know-how somehow. You send your IT experts into, you say, we need to review everything in your company, we need to review because we are ready to invest billions. So you send your advisors there and you say, don't care for corporate history, don't care for IT security, just get me the information. It's illegal, but the enforcement of that You know, so you're telling right. A question on top of that. Can you guess what is the situation that I am running a company, what is the situation that I have my own business and I'm buying another business, not because I love another business, but I hate the other business? What would it be?
If it's in the same market to eliminate competition and use market share.
Exactly, exactly. If you are sitting on cash and you can be number one on the market because there is someone better than you, which can happen, simply buy them and become number one like this. So yes, buying a competitor is another reason for that. Okay, so now tell me the other way around. Why would I sell my company? I love the company. I have established the company 20 years ago. I have my villas, I have my cars, I have my planes, I have everything. Why should I sell my company?
I have question. I mean, let's suppose if he's buying competition. I mean, do you think, the competition law will allow you, if you are going to buy the competition and then there will be no competition in the market, it will be a monopoly. I mean, do you think competition law will allow you?
The competition law might be a limitation to buying competitors. We'll get to that, how this is solved in the M&A process. But yes. In general, in all jurisdictions, buying a competitor resulting in creating a monopoly situation will not be allowed. Even if both companies want to merge, want to acquire one another, the authorities will stop that. So why would someone sell his company? The owner has, sorry, I forgot to sell, if it is not a reason of money, because the company is super earning and you as a seller don't need the money.
I was going to say money, so we need cash flow.
Okay, so yes, first you need the money, but what are the other reasons? Those guys who established the companies 30, 40 years ago.
Maybe they do not have the managerial capacity to manage the company.
Right. There's been a progress. IT. There's been a progress, and they didn't get on the progress as well, and they see they are not that good in the management as they were in the last years. So they typically decide to retire. Well then, who's typically selling the companies? Startup guys. They never had the money. They invested their brains, their time, and now someone comes with the well, if it is a unicorn with a $1 billion, the startups sell their companies. So let's just summarize that. Buying a company. Well, there has always been a rule. I think, you economic guys, you tell me, there's always been a rule that you have to grow all the time because the shareholders push you, you push yourself to grow as well. So the way how to grow as the company is to buy other companies. So that's one reason for buying companies. If you buy a company which is profitable, you increase your profits. The shareholders are happy, you get your management remuneration increased, everybody's happy. Then you mentioned the access to the market, access to the technology, access to the know-how, which might be less expensive than creating the technology, going to new markets from scratch, or creating the know-how. Get rid of a competitor that was buying a company which you hate. Sell side. Well, the owners are already old. There is a question whether the correct way, and that's as I told you in the beginning, there is always a story behind selling a company. So you have two ways. You can give or transfer or sell, somehow get your company to your kids and believe they will run the company properly and believe that you would be able to hand it over. It's difficult. If it's your baby, you're not able to hand it over to your other baby. So if you are retiring owner of the company, you may consider this. Maybe a better option would be to sell the company and to support your kids financially. So that's why the owners retired are one of the reasons why companies are being sold. Then another reason is that the company is doing fine, but the owners see that the growth will not be as good as it was, the growth like that. It will be slower, maybe the company will stagnate. If I'm a responsible owner and I see the growth will stop, it's time to sell the company maybe, because I'm doing something wrong or the market changed, or I simply am not that reliable to the banks that the banks will give me that much cash as I need to grow further. And it can be because I'm not green enough, for example. I'm not using, I might be a, I might be a company which is doing perfect, but my factory is not good for the environment. So nobody wants to invest in that. Nobody wants to borrow money into these companies. Sorry.
For example, the company used to be good in the past, and
Please use the mic so that.
So another question?
for example, company used to be very good in the past, but they created very successful products, but they want to develop a very big product, but they don't have enough money to do it. So the main reason will be joining the big corporation, which can give those resources for that small company, which is not successful at all, to develop the
Right.
product. Yeah.
Right.
To get those resources which have the bigger corporation. Yeah.
That's absolutely correct what you say, that a company can stop growing because it doesn't have the resources to develop new products. Also, it was super successful in the past. And my experience is that the super successful companies in the past have the shareholders which are used to getting money every year, nice dividends taken from the company. And now the product is out-fashioned and the company needs to develop a new product. But the shareholders say, no, we want our dividends. Don't keep the money for the development. Give us the dividends.
And also, for example, many products, they go into the market which aren't finished because investors saying, no, we need to launch the product on this exact date.
Right.
But the company workers say that we cannot do it for 1 year, we need at least 2 years. But the investors said, no, we need it right now, so the product can be launched very badly, actually.
I tell you a case from 2 weeks ago. There was a very successful company selling T-shirts, shorts, kind of funny, nice color stuff. They invested. It's young boys, girls after school established this company. They have their production here in the Czech Republic. Part of the production is in Asia as well, which is fine. And they invested a lot of money into marketing because the company was going super, and they said, we will growth, we will have, during the main TV news, we'll have our advertisement together with the banks and these large companies. So we'll be there, our clothing company will be there. So they invested a large money in, they have invested a lot of money into marketing. It worked. The marketing was perfect. Everybody knows the advertisements here in the Czech Republic. Everybody knows the company. But the problem was that the transportation market is broken because of the war, because of COVID. It's broken for the last 2 years. So they have many the people, they have many customers. All the customers want to buy their clothes, but it's stuck somewhere in the transportation city, somewhere on the road, and they are not able to deliver. So they are not able to sell, but so there is no cash coming into the company, but there is cash coming out of that company because they need to pay the marketing, which was contracted already. So the company is perfect, the product is perfect, there are customers, but now they asked, or the rumor is, and we've seen the basic terms already. The company is for sale because nobody at this moment will give them the interim finance to overgo this difficult situation. So let's go now to, if you want to buy a company, how you would do it. Don't be scared. It's the easiest way how to do it. It's the easiest structure of buying a company. Here is the target. It's the company we want to buy. We are the buyers here. We have created a new company five days ago, which is called SPV, meaning Special Purpose Vehicle. SPV, it's a typical abbreviation in M&As. Everybody talking about SPVs. So SPV means Special Purpose Vehicle, a limited liability company. It has no business, no income. It is created just for the purpose of buying the target company. So here's the seller. It's the one who wants to get off and sell the company to the buyer. But I mean the SPV owned by the buyer. So if the buyer is clever and the market conditions, and maybe you economic guys will tell me that it's not the situation now, and the market conditions are fine, so what you will do? You'll go first, even before you create the SPV, you go into the bank and negotiate with them whether they would be willing to lend you, to give you a loan from which you can pay the purchase price for the target to the seller. The bank will say, yes, we like the target will grow, it's valuable, so we like the target, that's fine. We like you because you have loans from our bank in the past, so you have paid that, repaid these loans, so we will give you another loan for this acquisition. So the bank, and it's very important, the bank likes the deal. It's very important. So then, at this stage, you create the SPV. You put your own money into the SPV. Like a shareholder, you push the money down to SPV, And it's going to be the monies which you earned. It's going to be your own money as the buyer. The bank, at some stage, will bring the money into SPV through a loan. So you will not be the debtor of the bank, but the SPV will be the debtor of the bank. The loan will be here, not to the buyer, to the SPV, which is good for the buyer. There's no risk vis-a-vis the bank. Of course, the bank is trying to have some comfort from the buyer as well, but the loan technically goes into the SPV. So now we got the SPV, we got the money from the buyer in the SPV, we got money from the bank in the SPV, so we're ready to pay the purchase price to the seller, and in exchange for the purchase price, the SPV becomes the shareholder of the target, and the seller is out with his purchase price on his bank account, and the target has the new owner, which is the SPV, which is fully controlled by the buyer. If you don't see this, the customer and incomes, you know the SPV is the debtor vis-a-vis the bank. So it's the SPV who needs to repay the loan. You will not believe in that structure because the SPV doesn't have any income. How will the money flow into SPV so that the SPV can repay the loan to the financing bank? There's no income here. SPV doesn't have any customers. It's 4 days old company. The only asset which the SPV owns is the share in the target. But you know, the thing that the target has some incomes from its customers doesn't mean the cash will go in there. It remains. Generally, at the end of the year, I can pay out the dividend, which is fine. But the bank asks me to pay on a monthly basis from some point. So the target is happy. It has a new shareholder. The target has its incomes from its customers, as it was in the past. The buyer is happy because he owns indirectly the target and is waiting for the dividend. The only one who's not happy is the financing bank because there is no cash in the SPV which can be used for repayment of the loan. So in that, the banks of course know this, so they will not let any money go into the SPV unless the SPV agrees that, or procures that the cash which is in the target may be used for repayment of the loan by the SPV. You may say it's legally prohibited that the target company actually pays the loan because the loan is for the benefit of the buyer. That is absolutely true. Why would this company give money? Why would this company give money to the bank? Why would this company give money to the bank? For a reason that the bank gives money for buying shares in this target. It's quite complicated, but from the target would have no gains, no advantages from paying any monies to the bank. It's not in the interest of the target to have a new shareholder. They were happy here with the seller. They don't care if their owner is a seller, buyer, SPV. They don't care. They do their business, and their goal is to have enough cash for for investment into development, for running their business. They don't care about loans of other persons. So the bank in an M&A transactions tells you, as soon as the SPV becomes the shareholder of the target, we need to get access to the target's monies, and we'll do it in a way that the SPV and the target becomes one company by way of a merger. So I will repeat that. I am a debtor, SPV. I don't have any cash to pay the bank, but my asset is a share in a company which has the cash. So I make this SPV and this target one company, which means that this one company has the cash which originally belonged to the target. And this company has also the incomes from the customers which originally belonged to the target. And this company has the debt which it inherited from the SPV. And this company can use this company's cash to pay this company's debt towards the financing bank. So this is, sorry if it was too much, but this is the most simply acquisition structure in an M&A process. It would be much easier if there is no bank financing. If you don't have the bank, it's easy. The buyer pays the money to the seller and gets the target, and it's all done. But if there is a bank financing and a bank loan, you would need to, from this part of the deal, you need to get the cash to pay the bank. And the bank will not allow you to pay any monies, any dividends up there to the buyer until the bank loan is fully paid up.
Well, I have few questions, honestly speaking. SPV is, you mean that it is a special generate new company they have established. Let's suppose buyer is sitting in USA and customer is sitting in Czech Republic. Okay, so buyer has made a new company that you're calling SPV in Czech Republic, am I right?
Okay.
All right. Okay, and then why he is not buying the target under his name, and why he's creating SPV? Is just because of financial bank or why? I mean, we can have like one by one question answer, then we'll keep moving on. First of all, why he's creating SPV instead of coming with his own name and buying directly? Will you answer?
Okay, I'll answer now. So the question is, why does the buyer need an SPV here? Why doesn't the buyer buy the target directly? So two reasons. One is, if you go for the financing from the bank, then you need the SPV to get the income from the target through the SPV to the bank, because you will not be able to merge the target and the buyer. It could be a physical person up there. So there's one reason. The bank will require typically a clean new company with no history, with no liabilities, no assets, just a company which is just created in favor of the bank, for the bank. Another reason is, what if the target is not as good as you expected? It can go bankrupt. Or, and it can happen easily, the transaction, the purchase, is aborted. It's broken during the negotiations. You disagree with the seller. The seller goes away from the table, never pick up a phone again, never answer to an email. You don't want to be a buyer to be chasing the seller. Here you have your own asset. Here you have no asset. You want this company to do the job for you and to be the contractual party for the seller rather than you directly.
So the main company, basically that might be the big group or investing group, doesn't want to come in the picture, and they want to establish SPV to have a smooth transaction with the seller, and also there will be and might be they also want to have a local establishment in that company, that country. So that's why they wanted to have SPV in that local country to facilitate or to get the facility from the government, from the bank, and to establish a company. Am I right?
Yeah, that's correct. And one more reason, maybe once you decide to sell the target to someone else, after 3 years you take out the dividend, and you let the company go to someone else. At this stage, from various tax reasons, it's much better than the selling that the selling entity would be the SPV for various tax reasons. If you don't merge it, you still have the SPV, so you have the target, and you are selling this share to someone else after 5 years or something. So there might be tax reasons as well, legal tax reasons.
So this SPV will be 100% owned by the buyer?
Right. That's the typical structure.
Another reason, like you mentioned, the SPV is a limited liability company.
Right.
So wouldn't it be like for protection to the buyers of these
Absolutely.
assets are not on
Absolutely.
the table in case you can't trade back the loan? It's just the SPV who's answering for the loan.
Yeah, exactly.
And
It's the protection of the buyer.
moreover, financial bank, I mean, because is going to give a loan or bank loan for buying, the new target. I mean, it's a very new company. I mean, they don't have any assets. They don't have any success story behind it. How the financial bank will take the risk to give the entire amount to SPV to buy the target?
I don't want to go into details, but a simple response would be the bank will not only get to the cash of the target, but they will also get to the assets of the target. So if the target owns a real estate, the bank will get the pledge over the target's real estate. They have in this structure, and as I said, I don't want to go into the details, but the financing bank will get to the target's assets, which can then be used as a security for the bank. So let's go phases of M&A process. So if I ask you, if you have a company which is not that large, I would say it's your family business. I mean, small production company, small travel agency. What would be your guess for a time needed for selling this company to someone? Would it be months, 3 months, year? And I mean, consider the period from the time when you say, I will sell the company, to the time when the cash flows into your bank account. So who think it's typically less than 6 months?
I guess it varies by jurisdiction.
Mm-hmm.
And depending on the value of the company, it will depend on the period as well.
Mm-hmm.
I guess that's a pretty good answer, but maybe if it's a small travel company, and they want to sell it, usually I think happens between less than 5 to 6 months.
Mm-hmm. Are you the only one who think it's less than 6 months? If it's a family business? Because I would say it's doable in 6 months. It should be doable. It should be doable in 6 months because your idea of selling the business doesn't come out like this. When somebody decides to sell the company, he already has in mind a potential buyer, or he knows where the potential buyers may be. So it's doable in 6 months. In larger transactions, like production companies, factories, I would say 6 to 9 months is perfect. Typically, it's 12 months. Typically, it's 12 months.
Well, but don't you think, I mean, the buyer should wait? I mean, let's suppose he's in the first quarter of the financial year, example, okay? And or mid of the financial year. So the buyer should wait to submit his financial reports, the tax reports to the government, to know more about the financial strength of the company. I mean, might be he's hiding something or he's not having clarity. So he should wait until his submission of the financial report to the government and tax report to the government. Then he should decide that either it's 6 months or going to be 8 months or sometimes, you know.
I get your questions. I get your question. It would be perfect if you have a time to wait, but whenever you wait in the transaction, the seller will start to be nervous. They will say, are they really waiting for the financial statement? Isn't there another potential target for them on the market? Aren't they in financial problems? Are there, for example, don't they need more time to persuade the bank? So, you know, my experience is whenever there is a delay in the transaction, the first thing I do, even if it's a delay that the owner is on holidays, the first thing I do, I pick up a phone and I call the other party and I say, there is a delay and the only reason is that. So I don't want them, and I never leave them speculate on the reasons for the delays because you know, it will typically mean that they will look around whether there is another buyer, which means the information split on the market. And I may be the one who buy it at the end, but I will need to compete with someone else who got there because there was a delay, unexplained delay. So my experience is typically no. So the phases of M&A process are four. Four phases. The first is the pre-contractual stage. Very important. Very important for us as lawyers. And is there someone who's been on a negotiation course? Like, does someone have a training in negotiations? Any negotiations?
We have some sort of
Right.
negotiations while we are like a business.
Okay. Put the fish on the table. These rules. No. I'll get to the negotiations in M&A. The pre-contractual stage, everybody say, well, it's a 3 pages document, non-disclosure agreement, letter of intent. Why is this in the letter of intent? It will be in the main agreement. Let's just sign it and go ahead. We don't want delays. Legally, this is a very important part. This is very important part of the M&A process because what you are able to negotiate here in the pre-contractual stage without any papers, in exchanging emails and stuff, it will be very difficult for the other party to renegotiate when they get the first draft of the share purchase agreement. So I'll get to that. Due diligence stage, it's a nice one. It's a nice one. You get the documents, you get access to a virtual data room. You can go through the documents in the evening. Nobody chases you because you have six weeks to go through the documents. So a lawyer and a financial advisors, it's like when they go into the library and they don't make phone calls. They just go through the documents. Very pleasant part. Very pleasant part. I get to that again. And then there is the contractual stage. The most important documents is the share purchase agreement. The abbreviation you can hear everywhere in M&A is SPA, share purchase agreement. It's the main document by which you sell the shares and you buy the shares. And we'll get to that. There are some other documents, like you need to have the financing documents with the bank, management contracts, but it's details. Every document which you signed in the M&A process will be referred to in the share purchase agreement. So the most experienced lawyers, most experienced advisors you have, send them to negotiate and to draft the SPA, and have juniors and other staff to look at the management contracts and the rest of the documentation. So that was about the timing. That was about the timing, as I mentioned in the beginning. And there's my note on the negotiations. You know, if you are a buyer of the company, make the seller happy, let's say. At this stage, make them happy. Start to negotiate at the end of this pre-contractual stage, because there might be some emails exchanged, there might be some basic documents signed, so negotiate here. During the due diligence, well, use the time which you have for going through the documents to negotiate the particular parts. And then, of course, the negotiations go here with the contractual phase. And in the beginning, don't spoil the transaction by negotiating until the very end. What is important for you in the contractual documentation should be negotiated here. Because if you don't do it, and you negotiate until the last minute, nobody will be happy. Nobody will be happy. Even if the deal is nice, the client will say thank you, but will never like you again. You know, it's not about making last time phone calls, bringing last time requests on the table. Make the transaction nice so that everybody is happy, the seller and the buyer. The reason why I'm saying is, after we sign the agreement, there will be some operational problems. Something will be missing in the company. Something needs to be explained again. And if you spoil the relation here, it will be difficult to integrate the companies with the new owner. So that's for.
At what stage? I mean, you know, you have mentioned 3 stages: pre-contractual phase, due diligence phase, and contractual phase. At what stage the parties will decide the monetary value? I mean, what will be the buying and selling value?
At the end of the due diligence stage.
At the end of the due diligence stage.
And I get to that. In the due diligence. It's important part of the, that should be my main information to you from the due diligence process. So I'll get to that.
All right.
So we're going for the due diligence. I mentioned the abbreviation. M&A is one abbreviation, SPV is one important abbreviation, and SPA, which means the share purchase agreement, is the important abbreviation. And other important abbreviation is DD, due diligence. Due diligence. What does a due diligence mean? I have already said that the buyer gets his legal advisors, his financial advisors, accounting advisors. They receive documents, they review the documents, and they report the results of their review to the client. What is the purpose of the due diligence? Because what we often see is law firms or financial advisors are doing due diligence, but you read that through and you say, well, it's nice, I got to know the company, but what does it mean? Does it mean, shall I buy the company? Shall I run away from the company? Shall I buy the company for a lower price? Or are they trying to say that I'm paying too low purchase price? Shall I pay more? Is it what they are saying? So anytime in the due diligence, you need to look for the purpose. So what's the purpose of the due diligence? You mentioned that the due diligence should confirm to the buyer that the purchase price which the buyer intends to pay is okay, that the company is worth the purchase price the buyer is going to pay. Because what is the process? If I would be selling a company, I would go to you and I will say, the company has 2 cars, 20 customers, turnover of 1 million, and profit of 100,000. You say, okay, I like the company. If this is true, I will pay you the purchase price you want. So then you go for the due diligence, and the due diligence people, the due diligence team should tell you, yes, the information on the basis of which you calculated your purchase price is correct. So the purchase price calculation is correct. So it's the main purpose of the due diligence. And the thing is, the final valuation of the company will be, and the final purchase price, which is related item, will be known to you not after you finish the due diligence, because you take the due diligence results, or at least a summary of the due diligence results, and you go to the seller, and you are explaining, we have found this problem, which means we can't pay that much. Are you fine with that? And the seller say, yes, we are fine with that. We will lower the price here. Or the seller say, no, we're not fine, but we will give you a longer warranty period for this matter, because it is an issue, you have identified it, but it will not materialize. You will not be beaten on that. So on the basis of due diligence, you go to the seller and you negotiate the purchase price. In the meantime, you can work on the SPA, on the share purchase, but the negotiations of the purchase price follow the due diligence and are dependent on the due diligence result.
Hello, sir. Yes. While you're negotiating, like large size companies, of course, if the company has a good value, and good reputation in the market, they would also ask for the goodwill. How you will, or what are the criteria to determine and estimating the goodwill if you are buying and selling such type of companies?
It's a very difficult question. Very difficult questions going more to the economics. It's difficult. It's difficult.
Will estimate it, or the auditors or the external financial bodies will estimate it?
The financial advisors will do so. The M&A advisors will do so, but they will ask the lawyers for support. So we're ready to get that, but it's difficult. It's not only the goodwill. There are many other things which need to be evaluated within the due diligence process. So here is just the list of what we are looking at for the due diligence. I would say, if someone asks you, what would the due diligence be about, tell him about everything. You'll get stupid questions. Not because we're stupid, but because we need your confirmation on that stupid questions that it's okay. We'll be asking personal questions. And it's a problem of the due diligence. Sometimes the sellers say, you want too much. And you need to explain. Anytime you ask the seller for information, you must be ready to explain why you need this information. Otherwise, they will not trust you. They will not trust you, and they will start giving less and less precise information.
Is that part of the reason why they signed the NDA on the first phase?
Yes. We'll get to that. We'll get to that. The NDA, which means the non-disclosure agreement, it's very important. If you ask the seller to give you the information of the company, any information on the company, you must give them the comfort that you will not use, you will not post it on the internet, or you will not use it for another purpose, like selling to the competitors. Or you will not use it for your benefit if you are not buying the company, in fact. So yes, the NDA, it's a must. Otherwise, the seller shouldn't give you any information. And another thing is the preparation of the seller. I'm telling the clients, the sellers, you'll get naked in front of them. They will see everything. They will ask for everything. Get ready for it. Get mentally ready for it, because it's the part of the game. So getting the sellers ready and being able to explain to the seller why you need this information. A stupid situation, and it can harm the entire process. It can result in the seller going away and not selling the company worth billions. If the seller asks you why you need this information, and it comes out that it's an information which you ask everyone, it doesn't help to anything, it's not related to the company, it's not related to the particular deal, then you would feel stupid, and you're losing your negotiations position. You know, nobody would like to deal with you. So how do we get to the information? Coffee break will be in 7 minutes. How do we get to the information? Well, first thing, we send the seller 10 pages of requests asking, give us the agreements with your customers. Give us a list of your, anonymized list of your employees stating their positions. So this is a typical request list, and the seller goes through the request list and puts the requested documents into the data room. What is the data room? It's a place somewhere on the internet where you can display the documents online. But even if you are not able to download the documents, even if the documents are marked as confidential, be sure that if there is a virtual data room, there will be someone, there will be an IT guy who will be able to download the documents, or if not, they will simply put an assistant making photos of millions of pages. So that's why some of the sellers use a paper form data room for very privileged information. For example, we're asking, are you sued by someone? Is your company sued by someone, by a competitor? And they say yes, but we will not give you the documents. You can send one person. It must be a senior person who will not have his mobile phone with him, who will not have the papers to make notes. He can review the documents. He can memorize them as far as he can, but will not give it to you in any way. And they say, we'll allow the person there to be for an hour. Yeah, so they give you the information, but it's so privileged that they can't give it to a data room. Okay, so of course you check the publicly available information. You ask additional questions, additional requests from the seller, and what is a nice part of the M&A process is the management interview. The seller typically, at some stage of the process, they allow you to access directly the managers of the target, of the company which you will buy. And imagine you are a manager. You have your owner sitting behind you. It's the one who pays your salary. And you have the buyer who is, and you know that everything goes well. The buyer is asking you questions, and you know that the buyer is going to be your next boss next month. So they are kind of trying not to say too much because of the existing owner, but trying to give as much information as possible because of the new owner. It's a competitive role. Nothing good for the managers, but it's typically very pleasant. The negotiations with the owner may be tough, but not the management interviews. It should be an introduction to a future cooperation. So, that's 7 minutes. We got time. I will show you. Of course, when you finish the due diligence, you have to report it to the buyer. We're using these these colors just to make attention: high risk, medium risk, some risk. But what I wanted to show you is how, in practice, and it's copy-paste and anonymized from a due diligence report on the cosmetics company, which I told you about. So there is a cosmetics company producing hair cosmetics and selling all over the Europe. It has two owners, and one of the owners is a limited liability company. And here in the due diligence report, in the due diligence data room, you find out a cooperation agreement which says every year this target, this cosmetics production company, will pay certain management fee to one of the shareholders because it somehow helps the company to manage its matters. So this is very important for the client to know. First, when the client buys the target, the target may not pay any monies to the shareholder which sold the company, to the previous shareholder. So this agreement needs to be terminated. And of course, you know, if the company sends money to its shareholder for some management, which can't be measured, can't be really seen, many times can't be good evidence, it might have effect on the value of the company, on the purchase price, because if you report this to the client, so the client should tell his financial guys, go into the numbers and find out how much has the cosmetics company paid to this company X. How will we handle this in the purchase price, because it's not standard. So this was just to show you how a due diligence report look like. My plan is, because as you know, it's public holidays in the Czech Republic. The offices are closed, businesses are closed. So my suggestion would be, when we finish the documentation in the M&A process, let's stay for a while and let's discuss more informal things on the M&A, such as, you may ask, how much does a M&A advisor charge a fee for bringing a company for sale? How time demanding is to be involved in the transaction process? Stuff like that. I would be happy to answer these questions. So let's get started so that we have a time for that as well. So there are three main documents in the M&A process which I would like to discuss with you. We have, it's the non-disclosure agreement, the abbreviation NDA. We have discussed that. We'll go through it very fast. Letter of intent, LOI. This is something I would go more into the detail because I would like to make a note on the negotiations, which I already did partially. And then we'll go to the share purchase agreement. And here, with the share purchase agreement, with the very crucial, most important document in the M&A, the goal here would be that besides that you would be able to read the SPA, the share purchase agreement, in any jurisdiction, because you know the structure. I would like you to understand two things only. One is the purchase price mechanism. How does the SPA define the purchase price? How can the purchase price be increased or decreased within the SPA, within the SPA framework? And the other thing is, I want you to understand what the seller is liable for when selling a company, and what is the seller liable for, and to what extent is the seller liable. Nothing more. These are the liability and the purchase price structure are the two most important things in the entire SPA. But let's start with something easy, which is the non-disclosure agreement called NDA, confidentiality agreement, various names for this agreement. Interestingly, this agreement is between the buyer or the SPV, the seller or the target, because typically it's the target who gives you the information, because it's information about the target. When you are asked to sign a non-disclosure agreement, and it doesn't need to be an M&A transaction, it can be in your personal life. So what you should know is that the NDA will ask you to keep the information confidential, which means on your side that you have to take measures to make sure that the information remain confidential. In M&A world, it means you will not store this information in unprotected IT area, for example. And another very important fact is that the NDA always requires you to use the information only for the purpose of the transaction, meaning you got the numbers which you can use for calculation of the purchase price. You have the copies of the customer agreements so that you can check whether the customers may terminate the agreements with the target because they don't like you as the new owner. But you can't really use the information from the customer contracts to go to your customers and say, hey, in that company, the terms are different. We want to offer you the same terms as our competitors do. So this is not allowed. Even if you don't say this so explicitly, but you will use their information to renegotiate agreement with your customers, this would be a breach of the non-disclosure obligation. As to the signing, we have already mentioned, responsible seller will not give you any information on the target company unless you sign, unless you as a buyer sign this non-disclosure agreement. So, what is the most valuable information which you receive in M&A? It's the first one, that the company is for sale, or that you are ready to invest into buying companies. And imagine that the company, the target company, is publicly traded. So imagine that you are a publicly traded company and you're considering looking into matters of another company with the possibility to buy this company. Well, it's an information which will form the price of your shares, which are publicly traded. So the most valuable information covered by the NDA, by the non-disclosure agreement, is the transaction itself. Then typically it's business information, products, know-how, suppliers, trade secrets. In fact, any information which you receive, you can be sure that any information which you receive within the M&A process will be covered by the non-disclosure agreement. Okay. You can imagine that the SPV, the special purpose vehicle, which will serve as the buyer's entity for the ultimate buyer, will sign the non-disclosure agreement. If you are the seller of the company, you should definitely require that not only the SPV and the buyer are bound by the non-disclosure obligation, but that also if they give the information to their advisors, especially lawyers, that the lawyers and their other advisors, technical advisors, M&A advisors, financial advisors, will be bound by this confidentiality undertaking together with the buyer and the SPV, because where would you say in an M&A transaction is the risk that the information will appear somewhere? Who will be the one who will take the information out? It will not be the seller, because it would be against him to bring this information. It will be a lawyer, typically, because the lawyer has other clients who may acquire, who may be interested in acquiring the company if this deal if this deal is not completed. So typically a lawyer of a buyer will bring, or a lawyer or an M&A advisor of the buyer will bring another potential buyer to the seller. So make sure that if you give information to the seller, the seller's advisors are bound by similar confidentiality obligation. What if there is a breach? In our experience, nobody is ready to accept a contractual penalty for a breach. You would be in a situation where you would need to prove that there was a breach, which might be easy, but you would need to prove what is the damage which occurred as a result of this breach, and it's difficult. And it's difficult. So it was about non-disclosure, a confidentiality agreement. We'll go now to the letter of intent. It's the document which might be 1 to 10 pages maximum. I mentioned in the beginning that the letter of intent, the parties don't care much for that. And very often in a transaction, it comes out that it was a mistake. It was a mistake because everybody forgets what is written in the letter of intent during the due diligence, which is long. There is a lot of information, a lot of exchange of emails. Everybody forgets what's in the letter of intent. Then the opposite party sends you the first draft of the SPA, of the share purchase agreement, and you have your letter of intent beside the SPA, and you simply send the share purchase agreement back, and you tell them, hey guys, there was a letter of intent, you probably forget about it, so rewrite your share purchase agreement, your first draft, so that it is in line with what we have agreed before in the very initial stage in the transactions. And if you were the one who prepared the draft of the share purchase agreement, what will you tell me? Will you tell me, no, it was just fun, the letter of intent? We know, I must tell you, the letter of intent is typically non-binding. But, tell me the argument which would persuade me to step back from the letter of intent and to start reviewing your first draft of a share purchase agreement, which is not in line with the letter of intent. So I don't see any argument against, gentlemen, we have agreed on something, and you're giving me something else. I will not even read it. So that's why I think the letter of intent, there should be attention given to that. But on the other hand, it's non-binding. It's non-binding. There are some parts which might be binding, and it's the repetition of the confidentiality included in the which is typically included in the non-disclosure agreement, so it's repeated in the letter of intent. But very important thing is the exclusivity here. Maybe the seller will not give you the exclusivity. They will tell you, I'm selling company, I'm running a tender, there are 10 others like you, so you don't have any exclusivity. But you go to the seller and tell him, look, give me exclusivity, negotiate with me only, and I'll be able to complete the transaction within 4 months, for example, you know. Even if there is a tender, it's not state companies buying and selling something. It's not a formal tender. It's a tender privately organized. You can always go to the seller and ask him for exclusivity. So giving you the opportunity to make the deal first, you of course have to offer a good purchase price.
Usually who offers, or who, I mean, you know, there are one is buyer, one is seller, right? Seller wants, or he will inform the buyer that he need this price, or the buyer will ask him that he can offer this price. I mean, what is the price mechanism, I mean, to decide?
Okay, the question is, who is the one who kicks off the amount of the purchase price first? It's the seller. It's the seller's advisors. The mechanism is rather difficult. They don't tell you, we expect the purchase price in the amount of, but they tell you, when you calculate your purchase price for your offer, you should assume that profit is as such, revenues are like this, liabilities are like this, and you make a very simple calculation, which gets you where they wanted to have you. So you can make some calculation, but on the basis of their information. So honestly, it's the seller who make the first step and propose the purchase price.
Yes, another, as you told me that yes, goodwill will be determined by the financial assets or economic expert. But do you, being a lawyer, I mean, M&A lawyer, do you have an idea that what could be the amount of goodwill? Like example, 20%, 30% of the value that of the business you have?
It depends. I don't have the idea. I don't have the experience here. So what's in the letter of intent? So you say who's buying what, for what price. It would be good if you could, in the letter of intent, explain to the seller what would be requested from them. So we will need this document, share purchase agreement. We will need we will need your support as the seller for our financing bank so that we can get the financing. You can explain in the letter of intent, you can explain to the seller that you would very much appreciate if they could meet with your bank so that the financing for your deal goes smart and stuff like this. It's very fair if you disclose in the letter of intent, if you are a buyer, if you disclose what are your capacities as time concerns to complete the due diligence. It's very unfair to sign a letter of intent saying we'll do the due diligence when we find our lawyers, when we find our advisors team. You should say we need six weeks to complete this. And you should indicate at what date, the latest date for signing of the share purchase agreement. So here on that slide, there is a note on what I said about the fact that the letter of intent is not binding, but I don't recall any transaction where someone successfully renegotiated in the SPA the terms which were previously included in the letter of intent. It is a possibility, but you would need to give something in exchange to the other party, and it will not be cheap. It will not be cheap, you can be sure. Legally, please keep in mind that when you sign a letter of intent as a buyer and you go away from the transaction because there is another investment opportunity or because your boss changed your mind. If you go away from the transaction, you can be liable for the transaction costs. You will need to pay the transaction costs to the seller, because it's not only you who invests money into the process, but it's also the seller who invested probably more money at this stage than you to make the transaction started. So please be aware that letter of intent, LOI, is a non-binding document, but it may have legal consequences, and it definitely will have consequences for future negotiations in the transaction. So let's go to the main part, and it's the share purchase agreement. In the transaction process, whenever you get from a seller the first draft of the share purchase agreement, it's a success. You are the one who made it through the pre-contractual phase. You made it through the due diligence phase. You were able to explain to the seller the results of your due diligence, renegotiate the purchase price, and you were selected. You were granted the opportunity to comment on the share purchase agreement. So it's good. You received the share purchase agreement, which is an agreement between the seller, as the selling party, of course, and the buyer as the buying party on the basic, not basic, on all terms of the transaction. If I tell you German production company, a supplier to automotive, is buying a Czech company, also a supplier to automotive, to the same customers, basically, and the Czech company is owned by Czech individuals. How long do you think the SPA will be? So it's an international deal, but it's not Asia, Europe. It's two states, one between just besides another. The legal regimes are quite similar. So how do you think? How many pages would you expect, without schedules, without annexes, just the legal provisions themselves? More than 100 or less than 100 pages? Less. Typically nowadays it's less. 10 or 15 years ago, a share purchase agreement which was less than 100,000 was typically not accepted. So it's now less. I would say it's 60 to 70 pages, but each word in that has a sense, has a meaning, and must be there in some way. So it's 60 pages of heavy text. The good thing is, especially in international M&A, and I would guess in any bigger M&A transaction within one jurisdiction, the share purchase agreement, if you put them on the table for different transactions, they would look the same, kind of same. The structure will be the same. And let's look at the structure now. Recitals. What is the recital? It's on the very top of the agreement. You explain why you want to make the transaction, the intention of the parties. Clients don't like it because it's not a legal stuff. It's just, in simple words, describing what was the reason for us to buy the company, what were the reasons for the seller to sell the company, but it's very important. Imagine that if there is a court action against the seller, it will get to the court probably 3-4 years after you sign the SPA. The first thing the judge or an arbitrator will read is the recitals. Here, you give him, I would say, you give him an instruction how to read the next 60 or 70 pages. Because imagine if you say, I, as a seller, made my company almost bankrupt. We had cash for another 2 weeks, and we very much welcomed the buyer here who will save us. So I'm saying I'm selling the company because I want to save the employees. I want to save the values which we created in the company, and I'm retiring. So this is one information, the first information which gets to the judge or an arbitrator. Or imagine the recitals will be, we as the leader on the market have decided to concentrate on other markets. That's why we have hired the most expensive M&A advisors in Europe to organize a tender. The tender which were organized, it lasted for 6 months. We selected 3 firms. We have them propose the purchase prices. And we selected the highest purchase price. You know, if the judge reads this, he say, "Oh, here is a very strong seller." Very strong seller, and a seller which is not forced to sell, a seller which has selected his buyer from 10 other potential buyers. So in the mind of the arbitrator or the judge, the way they will read through the next 60 pages of the SPA will be very much formed by the recitals. So also it's not legal, make sure that you describe the situation properly. Definitions, interpretations. Several pages of definitions. When you read the recitals, don't go to the definitions. Go into the main body of the agreement, go back to the definitions. Typically, clause 2 is the sell and purchase of the shares, the sell and purchase of the target. It's very simple. It's the main part. It says, the seller sells and the buyer buys the company. It's the main part, the most crucial. This is what we want to say by the share purchase agreement, but you would be surprised. It's 1, 2, 3, 4 provisions maximum. Very easy. We're saying we're selling, we agree to buy, we agree to sell if the conditions which are stated further in this agreement are fulfilled. If the conditions are not fulfilled within the stated deadline, we're fine. We keep the company. The buyer goes away. So that's what the sell and purchase part say. Then I mentioned that the sale will only materialize if certain conditions which you agree in the SPA are fulfilled. It means. And we get to that, I think, yes. On the next slide, you've been negotiating for 9 months. There have been a due diligence, 10 advisors on each side, and then there is a D-Day, a signing date. You meet in a conference room. There are 5 counterparts of the SPA on the table. It's been signed already by the advisors, checked several times, and you as a seller and a buyer, you come to the SPA. It takes you 10 minutes to sign it because you will not read it. You have your advisors there to read it in the morning. You sign it and you go away. You have the signed agreement, signatures verified, but nothing happened. You're still the owner as the seller, and the buyer is still a potential buyer only. But you have the signed agreement which says, if we, both parties, manage to fulfill the conditions which we just signed, there will be another D-Day where we will make the transfer happen, make the transfer of the target happen. And we'll get to what are the conditions which make the signed agreement being enforceable, legally effective agreement. So another important part which we will discuss, this is a typical structure. The closing, it means the day, the other important day, which I told you where the transfer is completed. What we look at in this presentation is representations and warranties. 80% of the share purchase agreement will be representations and warranties. A typical representation is I, as a buyer, represent or declare that the company has 20 customers in Europe, 10 customers in Asia. This is a typical representation. As a buyer, you are asking the seller to state as much representations and warranties into the SPA, because what the seller agrees to put into the representations and warranties, this is what you are buying. And I'll get to that. What is not written in the SPA is not something you pay the purchase price for. And then we're going to the liability of the seller. What if something goes wrong? It's the end of the agreement. It's not that long. It's about 10 pages typically. But most of the negotiations around the SPA, I would say this is 15% of the SPA. This is 60% of the SPA. This is 75. This is 10% of the SPA and the rest. And this 10% of the SPA, I mean the content of the SPA, takes 90% of negotiations. And I'll get to that. So the life of the share purchase agreement. I mentioned that once you sign the SPA, you are still the owner. If you are the seller, you are still the owner. What you have is just the signed SPA. And you have time to make sure that all the conditions which you agree with the buyer are fulfilled so that you get to closing or completion. Closing or completion is a date when it will take you not 10 minutes, as was the signing, but it will take you from 8 in the morning until 8 in the evening, where you will check that all the conditions were fulfilled. You will wait for the purchase price to come into your bank account. You will sign tens of other documents to confirm that you are leaving the company. New buyer, new shareholder is coming into the company, and you are confirming the amount of the purchase price, because there is an agreement on the purchase price, but the purchase price may be different on closing. And then the seller is away at this point. This is the new shareholder, the buyer in the company. And at this stage, the buyer is asked typically to pay the second part of the purchase price to the buyer. And then if everything goes okay, there are no actions under the share purchase agreement. We're just waiting for the warranty periods to expire. And in the warranty period, the buyer should have enough time to find out whether there are any defects of the target company. And if there are any defects, the buyer can claim something against the seller. And I get to that. So we've discussed that there are two important dates within the SPA, the signing and the closing. In practice, sometimes signing is kind of, nothing happens on signing. It's a work for the advisors, it's a work for the lawyers to check the documents, to prepare the execution version, but it's nothing for the seller. It's nothing for the buyer. They just agreed. On closing, the situation is different. The bank must be in place. The bank transfers must be agreed and prepared in advance so that the monies flow out and ideally flows into the bank account of the seller on the same day. So everything needs to be fine, and it takes the whole day, because on closing, the buyer becomes the owner of the company. So now, I mentioned in the beginning that what I would like you to know from the share purchase agreement are two things. One is how the purchase price is regulated in the SPA, and there are 3 ways, or 4 ways. And the other thing would be for you to understand how the liability of the seller under the SPA works. So let's go for the purchase price. The easiest way for a purchase price is to agree that I will buy your company for 1,000 euros. That's fine. We have fixed the price. We put the 1,000 euros into the SPA. We don't agree on any adjustments. We know that the company has the value of 1,000 euros, and we are fine with that. But I need to go to the bank to get the 1,000 euros. So it will take some time between we sign the agreement for the share purchase agreement for the 1,000 euros and until I bring you the money and you give me the company. So it takes some time. But what if, when I'm on my way to the bank, what if you call the largest customer of the company and tells him to get away? You don't like him. He'll get away before I come from the bank. And you ask me, pay me the 1,000 euros because we agree and we signed that. And I would need to pay it to you. It was my risk that you're going to pick up a phone and send away a customer because I agreed to the fixed purchase price. You are the seller in this case, and you fully control the matters of the company, the functioning and the business of the company until I pay you. And I need some time to pay you. So the fixed purchase price is, I would say, super beneficial for the seller, generally not accepted by the buyers, definitely not investment funds, definitely not in a situation where you need to go to the bank, where bank is involved. A fixed purchase price can be probably I can imagine the situation if my company running a business will buy a supplier of my company who has supplied all their products into my company, an exclusive supplier. At this point, I exactly know my supplier. And I believe him on the fixed purchase price. I know they will not. The relation between me and my supplier will not be destroyed until I get the money. So in a very specific situation, the fixed purchase price is okay. What we also see is if the transaction goes for a very long time and the seller and the buyer become friends, they believe to each other. They say, you lawyers, you financial advisors, don't elaborate on any purchase price mechanisms. Just, we agreed on this price, put it in the agreement, and don't generate any more work on that. It can happen. Then, a locked box mechanism. You will always hear when someone talks about M&A, if you are involved in selling a company, they will ask you, and the purchase price, was it locked box, or was it this closing account mechanism? So it's the two main ways how to fix a purchase price in the agreement. So the locked box mechanism is rather close to the fixed purchase price because you agree on the exact amount of the purchase price in the very beginning. When you sign the share purchase agreement, you include a fixed purchase price in the agreement, and you don't agree to any adjustments of the purchase price in the future. That's good. That's good for the buyer. That's good. That's good for the seller because the seller knows what purchase price the seller will get. But you must give a comfort to the buyer as well. You must give to the buyer a comfort that the seller will not call the customers and tell them to go away. That the seller will not pay dividend in the meantime, or that the seller will not, for example, sell the material asset of the target which you need for the target production. So if somebody agrees to a fixed purchase price within the locked box mechanism, it means then you will lock the company from the date of signing, where you fix the purchase price, until the date when you bring the money to the seller. Between signing and the closing, the payment of the purchase price, it might be a few days, it might be a few months. And you in the locked box mechanism, must make sure that the seller and the company will not do anything what you don't like. Typically, you say in the SPA that the company may not pay any extraordinary costs, something like that. The company may not pay dividend. The company may not, in the meantime, raise salaries. The company may not pay any special remuneration to the employees, stuff like that. You fix the company. You are trying to lock the company on the status which was there when you signed the SPA. And of course, if you are a responsible buyer, you leave your doors open. If they breach it, and if the company does something which you prohibited to them in the share purchase agreement, you go away from the transaction. You offer them a fixed price, and they disappointed you because by the way they did business after you agreed to the fixed purchase price, they did something to make it more expensive for you. So it's the lockbox mechanism. It's easier. Legally, it's easier. I'm happy to draft it anytime. Closing account mechanism, it is... Are you still with me? Isn't it tell me if I'm too fast, too slow, or if it's too much into detail, please. Closing account mechanism, if you forget everything about the purchase price mechanism, please remember the closing account mechanism. It's used in vast majority of all the transactions when buying, selling firm companies. There will probably be 60–70% closing account mechanism. What does it mean? It means that the seller becomes two portions of the purchase price. One is fixed, and it can't be changed. It can be changed. It can be changed during the time from signing of the SPA until its actual payment on the closing date. It can't be changed, and the buyer and the seller is happy because he knows if everything goes wrong, he will get this first initial installment of the purchase price. Then there's a closing. The seller gives me the shares of the company. I am the new owner of the target. I pay the initial part of the purchase price to the seller, and I know that I have some time to find out what was the value of the company, not on the signing date. For the signing date, for the value on the signing date, I paid the initial purchase price. But I have like a month, 2 months, 3 months to exactly calculate using my team, not the seller's team, to exactly calculate what was the value on the closing day. What was the value of the company when I actually became the owner of the company? So I become the owner of the company. I take all the documents, I give it to my team and tell them, please calculate the value of the company as of today, because now it's my first day in the company, I am the owner, and I need to know what is the value, because the value from the date of signing, when we signed a few months ago the share purchase agreement, it changed. And I know that in the share purchase agreement there is a mechanism which will reflect the changed value of the company in the purchase price. Typically, because you are fully on the company as a buyer, you still request information. Maybe you have your people in there already, so the value of the company is higher. So you need to pay the second installment or the second purchase price, second part of the purchase price to the seller. But it can happen that something goes wrong. It doesn't need to be a failure of the seller. The market might change. There might be other reasons, market, wars, COVID, anything, which means that the value of the company will be the same as it was on the signing date, or it might be even lower. In this case, I, as a buyer, would not be required to pay the second installment to the seller, and the seller would need to be happy with the initial installment. I don't want to go into details how you reflect the changed value of the company into the purchase price. This is something which goes for the financial guys, M&A advisors, and it's the EBITDA calculation, normalized EBITDA calculation. Maybe you will hear it in other parts of your course, especially in the financial, in the economic part. But for you who are lawyers, if you want to work in the M&A, make sure that you understand the calculation of EBITDA. Find a friend among your colleagues in economic and ask them to explain what EBITDA means, what normalized EBITDA mean. Otherwise, drafting the provisions on the purchase price would be very difficult for you, and you will not understand the instructions which you receive from your financial team, and you will not be able to write it down into the share purchase agreement, because they know it, but they are not able to write it. If you are requested to write it, and if you don't know it, you will never understand them what they want.
Well, sir, as you mentioned that warranties and guarantees will be there in the agreement, you showed the structure. And you're also saying that the amount will be paid, like the fixed price will be paid, and first installment will be paid, and the remaining will be paid on the signing date example. So how you are going to assure if the seller has, some liabilities which are not disclosed to you, because as you mentioned in warranties and representative. So in warranties, are you going to hold some percentage of the contract value, the selling value, or is just only verbally only assuring that he will be paying some warranties and guarantees?
I understand. You're asking if there is some liability, which I didn't know about because the seller didn't tell me there is a liability in the company. I buy the company, I find out there is a liability. This is not covered by the purchase price mechanism. I would go through the representations, warranties, and indemnity, which is the part which we will just discuss now. It's the 65% of the content of the SPA is the representations and warranties. Why are representations and warranties so important? When you buy a car, you don't check the purchase agreement. By law, by agreements, by general understanding, you expect that everything in the car will be fully functional. Because it's a new car, it needs to work. No exceptions. If you can't open one window on the back, you don't buy the car. It's broken. You don't need any specific provision in the agreement. It's simply a problem. This doesn't work for a company. Every single company has many issues. Accounting, something is not wrong, something is not okay with the accounting. It will be solved. It's not a problem, but it takes time to solve it. The customers, not all the customers are happy. It is normal. It is normal, and if you are a buyer, you expect that there will be problems in the company. But there are some problems which you are actually asking the seller to pay for because you're telling him it's your problems, not mine. And they are for me, from my perspective as a buyer, these problems are so huge that I want you to solve it. I know there are some minor problems, or from my perspective, minor problems, and I will solve them. I know it's in every company. But I want you to give me representations on what is for me as a buyer important, and if it doesn't work, I will go to you seller, to pay for that because it was your problem. So a representation is actually a declaration of the seller that something in the company is functioning, or that something is not in the company. Typically, a representation would be seller owns the target company because I'm buying sorry.
Again, I have still confusion. Well, you have mentioned in warranties that the seller will be responsible, and as you mentioned, that buyer will reach to seller and will ask him to rectify his mistakes or his concealment, what he has done.
Right.
Since he has sold the company, now the company doesn't have a legal status. So he is now a natural person. He is not owing the company. So he will be personally liable as per the representation of guarantees, or what is protection of the buyer in the law?
Depends who is the seller. Ideally, if it's a physical person, that's okay. You can go directly to the physical person. But typically, it's a limited liability company who sells the share in another company. So you need to make sure in the SPA that the limited liability company will not disappear until the warranty period expires. But we may get to that, because the way how you get to the seller's liability is that first, in the share purchase agreement, you persuade the seller to include an explicit declaration of what is important for you as a buyer. If I buy 100% share in the target, it's absolutely important for me that the seller is the owner because I buy it from him. So I need this declaration definitely in there. I need this declaration specifically, very specific, and I need this declaration even if I believe, even if I believe to the seller that he is the 100% owner of the target. I need this declaration even if I have found out in all my documents during the due diligence that the seller is actually the 100% owner. I need it in any case. I don't need it in a situation, I don't need the representation. In a situation when I go into the data room and I find out that in the corporate history there was a minority shareholder who was kicked out of the company, and I kind of sense there is a problem. Probably he didn't get paid that good for his shares. Maybe he was forced to sell his shares, etc., etc. So whenever I see a problem in the company and I find a problem in my due diligence, I don't ask the seller for a representation. I am asking for representation on matters where I don't see a problem, but I'm saying to the seller, I don't see a problem, but if there is a problem, you pay it. Here, in the indemnity, I know there is a problem, and I'm not willing to pay for it. I know there is a problem, I'm not willing to pay for it. I'm saying to the seller, you have a problem in your company. If I am forced to pay for this problem, I'll go to you using the indemnity, which is legally something different from representation. I'll go to you and you pay for the problem because we know there is a problem. But at this stage, when we are buying and selling the company, that we know there is a problem, but nobody is forced to pay something. Maybe there will be the problem for next 100 years and nobody will care. Maybe the minority shareholder will never come and tell me, I want my 2% of the company. But I know there is a risk, I have identified the risk. At that stage, if I have identified the risk, I can't really force the seller to declare that he is the 100% owner, because I know that he is not probably, or he might not be. So that's why I'm using a legally different technique, which is the indemnity. Unlike representation, indemnity is a solution for problems which were identified. On the other hand, representation is a solution for problems which have not been identified yet, but may occur in the future. So.
There is also any time duration for representative?
Depends on how strong a negotiator you are. If you are a strong seller, you will be able to limit the time for the indemnity as well. But generally, if I know there is a problem, I will not guess whether the problem will materialize. I will not guess whether I will have to pay for the problem now, in 10 years or 20 years. I know there is a problem, and whenever I am forced to pay, I want you as a seller to pay for this. So typically, indemnity is not limited in time, unlike representations, which are always limited in time. One common comment on both indemnity and representations. Indemnity and representations are given by the seller and are given only in relation to the time when the seller was controlling the company. Indemnity and representation goes always to the past, before to the matter. But by the indemnity and representation, the seller declares matters which existed at the time when the seller was the owner of the company. If something goes wrong when I become the owner, and it would theoretically be covered by the representation, no one cares. The representations go back. It lasted for some time, but it terminates on the date when the buyer becomes the new owner. Anything which occurs under the new owner is a problem of the new owner. So.
Well, another question, please. The new owner buys a company. I mean, does he has? Is allowed to sell to another someone immediately, or there is a time duration in the law that he has to run this company another 1 year, 2 years, then he will be able to sell it?
Some sellers want that, especially if it's a company which is locally important employer, and the seller is one of the guys who lives in that town, small town. So he say, these kind of sellers typically request that there is an obligation to run the company and not to sell the company in certain period. But it's difficult to negotiate it. But it might be. So the important thing is representations and indemnity are given by the seller, and it goes back to the seller's time. It doesn't go for the future. What is important? Anything which you don't have explicitly stated as the representation or as the indemnity, so anything which you don't have covered by the indemnity or liability is no liability of the seller. If you forget to state something in the representations and warranties, or you forget to include it in the indemnity, and you go to the seller and you tell him, well, that it's obvious that the company should have this license because your only business is this, so we didn't put it in the representation because it is so obvious, your fault. You should have put it in there. The seller is liability only for those matters which are explicitly stated either in the representations or either in the indemnity. Yes. So, and it's sometimes a surprise for an unexperienced buyer when you explain to him, we need to put everything in the SPA, anything you want the company to be needs to be written down here in the SPA, even if it's absolutely obvious. So, as you can see, if you represent a buyer, you put everything, 10 more minutes, no more, if you allow me. You can imagine that if you are representing a buyer, you put everything in the SPA and you tell the seller you are responsible for everything which is written there, and you put 60 pages of representations, warranties, and everything. But it's not a market practice that the seller is responsible for everything. The seller's liability is always limited in some way. How do we limit that? If I sell you the company for 1 million and you find out there is a problem, the only thing I'm happy to do for you is to give you back the million. If you find out I sold you the company with just 0 value, I will give you the purchase price back. But I will not give you the purchase price, twice the purchase price. Even if the problem in the company which I sold to you is 2 million, I will not pay you the 2 million. I got 1 million from that, so I'm giving you back. No more than that. So there is always a maximum liability of the seller. It is typically written as a percentage from the purchase price. 100% purchase price, 100% limitation, so you give the purchase price back, is typically if it comes out that the seller was not the owner of the company. So title to the shares, there's 100%. 50% is another threshold, then 20, 10% for different representations and warranties. We got statistics for different European states, and I guess it's in every state that there will be a statistics on to what extent the liability of the seller is limited. So if you are not able to negotiate better, go to the statistics and explain to the buyer that you are not, you don't want to go above these statistics. If statistically the liability limitation of the seller is 50%, you go to the 50%, no more. There's no reason for that. So this is more the most important limitation of liability of the seller. In practice, that does not, it is the most important when you concern the value. In practice, what's more important is a time limitation. Is a time limitation because typically the buyer, as a new owner of the company, it takes him sometimes to discover what's wrong in the company. It definitely, well, a buyer would not discover anything during the first year because there will be no new financial accounts, no new audits. Typically, after the first year, a buyer is able to discover a problem in the company. And then, when you discover a problem, it takes you a few months to calculate how big the problem is and to claim it against the seller. So there are, in every share purchase agreement, there are maximum periods in which the buyer may go back to the seller and request partial repayment of the purchase price, returning back of the purchase price. So typically the problem would be to make it to make the claim until the time limitation of the claims expired. Then, of course, the SPA is structured as that if you find a small problem in the company, you don't run to the seller directly asking for €5 problem. There are some minimum de minimis limitations, meaning that if you want to claim something against the seller, it must be of certain agreed value. We're not going to the seller for €5. And ideally, the seller would argue that one claim above the agreed level is not enough. The seller will tell you, I want you, if you want to come to me to give you part of the purchase price back, you have to have at least 5 claims like this. And then I am liable. Then I am liable. Thank you very much for staying longer than was expected. I'm available now for any questions. I mentioned the personal questions on the M&A market and gossips on the M&A market. And I think I'm fully open. If there are no questions, or if you have something else you need to do, please feel free. Who wants to stay? I'm happy to stay with you here.
Well, as you mentioned, as explained, limitation of liability. Do you have any exceptions to that limitation of liability?
Typically, what we are not able to agree is the limitation on the title to the shares. If I'm buying the shares, I will not limit the seller in any way for his liability for telling me that he is the owner of the shares and he can sell the shares. So not even 10 years, not even 20 years. I buy the shares and I want to be sure forever that I buy the shares from the right persons. The same applies to criminal liability. You know, once you tell me there is a criminal liability, I want this declaration to be there forever. If I find out after 30 years, I'll come back to you because it's so important material. So there are things which typically are not limited. And I must say, in practice, the case where someone sues someone for breaching a representation of warranty, it's not. Typically, the parties are able to solve it amicably by out-of-court settlement, before court settlement.
Another question. These days is, like I discussed with you during break time, the startup, the people are opening offshore companies, having startup, collecting the monies from the influencer and from the potential investors, and then somehow they can sell to someone else, and might be the buyer is also a co-partner in this, the deal. So what is the practice and how the law is protecting such, cases?
I would say generally, if the seller goes into an M&A transactions with fraudulent intention, you will not be able to protect the buyer 100% by legal ways. If there is a offshore structure, or if there are persons installed in the company which you would not be able to catch, or the company simply become dormant. You can have anything in the agreement you can imagine, but the enforceability will be low. And you mentioned the startups. I think it's actually our fault that we became in love with the startups. I think that the purchase prices which were paid to certain startups, or the investment into certain startups, were made on kind of happiness, friends, and expectations which were not reviewed as strictly as these expectations would be reviewed if it wasn't a startup. You always buy a company with an expectation, but you review it very strictly, the expectations, not in startup. I see the investors being in love with the startup founders. That's what you don't want. So I'm not surprised that you mentioned the case where startup takes investment and doesn't bring the value to the investor.